Hello, everyone, and welcome to the webinar today. My name is Alexandra Alvarado. I'm the Director of Marketing and Education here at the American Apartment Owners Association. It's so good to see you all again. We have a lot of information to cover today, but before we get started, I would love to remind you that we are going to send you the webinar recording tomorrow and any resources or contact information for the speakers today, so you can get in touch with them after the webinar. With us today, we have attorney Harry Barth and also Paul with us. Paul is also with BarthCalderon. Harry will be doing the presentation. Paul will be helping out with Q&A and also in our chat. Before we got on this call, Harry was actually talking to me about the Corporate Transparency Act, which, if you all don't know yet, is going to make a really big splash, I should say, in January. I'll let Harry tell you a little bit more about it. So we're going to just have a quick update first, and then we're going to dive into the meat of the presentation. There won't be any PowerPoint slides. Harry, he has all of it in here, and he will be telling you all that you need to know about providing generational wealth to your heirs and how to do it the best way possible. He's been doing it for 40 years, so this is definitely the person to talk to about this. He helps business owners, their families, corporations, franchisees. He is an asset protection advocate, and his workshops have helped thousands of families and businesses protect their assets that they have worked so hard to build. And I know a lot of those families and businesses are AAOA members. So we're really thankful to have you back on and to talk to us about this and give us really a really good update what exactly we need to know. So with that being said, Harry, I'm going to pass it over to you to get started, and we will take it from there.
Thank you, Alexandra, and it's great to be here. And a lot of things. So Alexandra said, splash, the CTA splash. Well, let's talk about that a little bit before we get into all the issues today of generational transfer of real property and asset protection of real property. Well, a number of years ago, the government had decided that targeting small businesses, small limited liability companies, limited partnerships, small corporations, indirectly trusts, or any other form of entity that gets filed with the government, that was a breeding ground for terrorist financing, money laundering, and tax evasion. So they decided in their wisdom, which in my opinion is probably one of the greatest intrusions into American privacy and compliance, to create the Corporate Transparency Act, which was passed back, I think, in 2020 with bipartisan support from in Congress and signed by the president. And basically, what's going to happen and it was deferred a couple years, but it looks like it's not being deferred any further. So effective January 1st, 2024, for all of us, and I mean all of us, if we have an LLC, a limited partnership, a corporation, it holds stocks, bonds, cash, holds a piece of real estate, holds a small business being less than 20 employees and less than $5 million of gross sales. And it's not one of the 23 exempt type of companies, which are like securities dealers, banks, nonprofits, things of that nature, that are highly regulated industries. So the stuff that most of us have, even like my law firm, are all now subject to the Corporate Transparency Act. And the goal here is to determine who owns and who controls that entity. And what they're doing is there's 35 million of these existing businesses in America. So I don't know exactly how this is going to shake out for the government. And they want to build a database of who are the owners and controllers of these entities. And so therefore, we're going to have to supply to, allegedly not for public use, but for governmental use, for their database, who is the owner of 25% or more, for example, of any LLC, their real names, their real addresses, not law firm addresses, not accountants' addresses, not PO boxes, not UPS boxes, actual address, and actual identifying, photographic identifying information, driver's license or passport will have to be filed with FinCEN, which is the Financial Crimes Enforcement Network, as a Department of the Treasury. So seems kind of straightforward. You file, you get a number, you use the number, you put it down, and we're all going to have to do this. So listen to me carefully. And I believe in February for AAOA, we are doing a 1 hour webinar just on the Corporate Transparency Act with much more detail. So what happens here is that what happens if we don't do it? Well, let's figure this. So for all of the entities that are in existence prior to January 1st, 2024, we have the year of 2024 to come into compliance. So we must bring, if you have 9 LLCs and 2 limited partnerships and 2 corporations, all of those must be in compliance by January 1st, 2025. If they're not, it's $500 a day fine for up to 30 days and up to 2 years of imprisonment. Isn't that thrilling and wonderful? So we got that coming up, and so there's some pretty heavy fines associated with not complying. But what makes the thing challenging, you know, if it's a simple single member LLC, and you're the owner and you're the manager, and it sits in your name, compliance is pretty straightforward. But if it's a multi-member LLC and trusts own the various different components, and the manager is different from the members. The managers who are in control are the control people. They all need to comply. All the members need to comply. When a minor turns 18, they need to comply. If you have 25% or more control, and it's with attribution, meaning that we aggregate with, you have resources from all different types, that's in trust, that's not in trust, you need to comply. If it's held in a trust, like most of us hold our stuff, and we're going to talk about it today, in whether it be asset protection trusts or living revocable trusts, then all of the trustees of those trusts and the beneficiaries that hold that 25% interest need to comply. If the LLC is owned by another LLC that's held by a trust, the basic LLC needs to comply, the holding LLC and its managers need to comply, and the trusts need to comply. And then in the trust, not only do we have the trustees, we have the protectors, we have the beneficiaries. In addition, if anyone has the right to remove and replace a trustee, they need to comply. So it is very, very intrusive, and the analysis is significant. Penalties are significant, but just be aware that this is here. It's here January 1. Now, there are cases, ladies and gentlemen, especially one that is meandering its way. Let me talk a little bit about 2024. For new entities that are created in 2024, which may happen as a result of our conversations today, it used to be that once that entity was registered with the state, so the state of California, state of Louisiana, state of Texas registers that entity, we had 30 days from the time of doing that to bring that entity into compliance. That has been, even in the last few weeks, changed to 90 days to bring it into compliance. But what is compliance now? So not only it's all the owners like I just described, and not only is it all the control people that I just described, but now as well as the people that help you form the entity. So my paralegal needs to comply on your behalf. I need to comply on behalf of my paralegal because we are the former of the entity. And then you have the controller of the entity, then you have the owners of the entity. So it is very, very interesting and very, very intrusive, very, very time intensive, and perhaps costly to bring everything into compliance. But ladies and gentlemen, absent a change or absent being declared unconstitutional, and there are about 4 or 5 reasons to declare this thing unconstitutional that is moving through the courts, we need to comply. We need to get ready to comply. It's not something we can stick our heads in the sand. We need to comply. It's just going to be standard. When we file an entity or put together an entity for you, you'll have to go through CTA and get a key CTA number and know that we're in compliance with the government registry. All right. So if not to make a morning wonderful and good, now let's turn around and get to the subject matter of today. So today we have a duality of subject matters to talk about. One of them is estate planning to move real property from generation to generation. So there are issues that are there that we'll explore together today. I mean, it's a goal. I own real property and I wanted to get to my kids, and um, but sometimes it's not so easy to do. So we're going to talk about what makes it not so easy. If we have the real property and the real property is not encapsulated, at least a minimum in a trust of some form, then upon our deaths, that real property winds up in a probate court, whatever your state calls the version of probate court. And that could be an 18 to 24-month process and very expensive and very public too, and trying to move that property from one. So that becomes difficult to do, to navigate through the probate process. And then it also probates, talk about probates. A lot of people have property in more than one state. So you might live in Texas and have property in Nevada, property in Ohio. And if it's improperly structured and not in an appropriate trust, there would be a probate proceeding in Texas, a probate proceeding in Nevada, and a probate proceeding in Ohio. 3 probates. So we'd have a probate wherever we have property if we have not fashioned our real property into an appropriate entity that helps avoid the probate process. Very, very important and very basic to moving property from one generation to the next. The next thing we need to be concerned about is in moving property from one generation to the next in an appropriate trust, which does avoid probate, is the potential for federal estate taxes. Let's talk about that for a little bit, or for a moment. Right now, the amount that a husband and a wife, or each individual, can move about $13 million, about $26 million worth of assets can move from generation 1 to generation 2 without the imposition of federal estate taxes. Now, federal estate taxes is no estate taxes between spouses federally. Now, in some states like Washington, Oregon, Pennsylvania, and others, we have state death taxes, New York state death taxes on top of the federal estate taxes. So you got to look at this entire tax structure. There, the limits are much lower. Like in New York, it's $6 million. And so we've got to take a look at that, because one of the attributes that real property has is not very liquid. So the estate taxes are due not between husband and wife, but between parents and children, for example, um, on the second death, or if there's no spouse on the first death. 9 months from the date of death, we have to write a check to the federal government for 40% of everything that is above the estate tax threshold. Oh boy. So that's really interesting. So right now, for many people with at least with a couple at $26 million, a lot of it's below that threshold. But and next year, which is just a couple weeks away, that threshold is going to move to about $27 million because it's adjusted for inflation. And then the next year may be closer to $28 million. So that's a lot to move from one generation to the next without the imposition of a 40%, 40% tax on moving stuff from one generation to another. However, we got a problem, Houston, we have a problem. Here it is. So by autopilot on December 31st, 2025, the Trump era estate tax exemptions, which I just described to you, automatically expire, and they return to the 2010 levels and with an adjustment for inflation. Best calculation almost universally is that it'll be $6 million a person and $12 million. So for a couple. So that means the estate tax is going to move from 40% of everything above 28 million to 40% of everything above $12 million. So alone, that's about a $7 million tax imposition. Now, for those of you that may not understand how our lovely government works at various different times, in order for this not to happen, because this is not something that's coming by legislation, this is autopilot. We would probably need to have a Republican in the White House. We would need to have a filibuster-proof Republican Senate and a majority in the House that's Republican. More likely than that, that will not happen. So therefore, more likely than not, the estate tax exemption will fall to the $12 million and 40% of everything in excess in 9 months from the day of the second death. On the other hand, in 2024, should we have a blue Democrat in the White House, and this has nothing to do with politics, everything to do with taxation, a blue filibuster-proof Senate of 60 senators that are Democratic, and a blue Democratic-controlled House, the more likely than not, that exemption amount will fall between the husband and spouse down to $7.5 million and 55% of everything that's in excess of that. So really, really confiscatory and really makes it difficult for us to move property from one generation to the next, because the purpose behind that tax, ladies and gentlemen, is to destroy, basically to break down your dynasty that you're building up in real property, forcing it onto the market and giving other people the opportunity to purchase the real estate, probably at bargain prices that you've worked so hard to build for yourself and your family. So what can we do? So I think it's very important for all of us to understand that when we look at this, there are tools and techniques that are helpful. First of all, every one of us, single, married, whatever our status is, needs to have appropriately designed game plan for the family called a living revocable trust. And to make sure that our real property, no matter how held, individually, in an LLC or limited partnership or a corporation, that those entities are in that trust to avoid probate. So we got that. Now, probate has nothing to do with the estate tax. Just avoid the probate process, that 2 years of expensive lawyers that's going on, and all the different states where it can be. So we want to have that. We also have an opportunity, and it keeps everything private as well, except for the database that's being built by the federal government under the Corporate Transparency Act, which allegedly is going to be private and only for governmental use. Well, I've heard that before. I'm sure you have as well. Not a lot of trust on my part for that will maintain the privacy, but they claim that it will be strictly private. And so therefore, if we don't want people with pitchforks and torches showing up on our front lawn, we still have ways to own your assets in such a way to keep them private. But one of the things I want to bring across to each and every one of you today is that we do have some runway. We do have some opportunity between now and December 31st, 2025, if we start early enough, to lock in that 26 or $27 million for a family and save $5 to $6 million worth of taxes. So inappropriate situations for a family, through the use of proper gifting and through the use of sometimes what we call non-reciprocal spousal lifetime access trust, we are able to lock in that $26 million. Now, it's $27 million. And now let's talk about that for a second, because that's really important and should be on the radar screen for those of you with any net worth north of $12 million. And do remember, life insurance counts. So if I got a $10 million net worth and a $5 million life insurance policy, that's $15 million, unless we make some consideration for the life insurance to get that out of the estate. But when you look at that, the spousal lifetime access trust, let me give you the three benefits. I won't give you the complexities today because we don't have the time of going through how we do this. But the benefits are we would lock in the 26 million or lock in the 13 million, whatever we have today if you're single. That's a good thing. So when it drops on January 1st, 2026, your family will not drop, and that'll save $7 million. But there's another component which I think is even more critical that a lot of people don't recognize. When we load our real property into these types of trusts, whether they be gifting for our children, gifted to the children, or spousal lifetime access trusts between spouses, all of the appreciation in the future. So if we loaded $20 million worth of real property into appropriately designed trusts and it was right for the family, then that 20 million grew to 40 million because we lived for a while. We all hope to live for a while. We lived for a while. That full $40 million will be exempt from future taxes. And that could be worth 16 to $20 million for the family. We have spousal lifetime access trusts and trusts we set up for children 10, 12 years ago with $10 million. They're now worth $100 million. And we save $40 million worth of taxes for families. This is something that should seriously be considered. It's complex. It has a lot of tentacles on that octopus, but it's worthwhile to consider when it's applicable and appropriate for families. So, and then the other thing that's really important is in these trusts, when they're structured properly, we gain asset protection. We're going to talk a lot about asset protection in a moment. So the assets that are inside these trusts will be, in most cases, free from the claims of the creditors of the people that set them up in almost any state where it happens. So we get asset protection, which is really important in today's world that we live in. We lock in the high level of exemptions before they expire, and all the appreciation can be eliminated from taxation. Now, as Alexandra said beforehand, there's another little component, which is the word that you hear a lot of time is dynasty trusts. So right now, there are two. This is a little complicated, so let me try to dumb it down a little bit for all of us. There are two taxes. You have the estate tax, which is the tax on transfer. So when my wife and myself want to transfer our real property to our children, if that property is subject to estate tax, it costs me 40 cents on a dollar in order to make that transfer with an illiquid asset that is very, very difficult to do, and many times precludes us from being able to transfer the goal of transferring our property to the next generation. So we all sit down and we're all smart and we think about, well, our kids are okay. Our kids are smart. Um, our kids have good jobs. The kids have a net worth of their own. And there's grandchildren there. So why don't we do this? Why don't we just make a gift of, of these assets and these properties to our grandchildren? Because then when we die, all right, we've used up our exemption. Our children are older, but our grandchildren are younger. They got a whole lifetime to live and grow that real estate without the imposition of a tax. Well, little people at night in the government think about that too. So they developed something which is called a generation skipping transfer tax. And the exemption amount, ladies and gentlemen, is the same amount as the estate tax. Right now, it's like 26 million bucks. So we can actually give to grandchildren $26 million worth of assets without the imposition of an estate tax and without the imposition of a generation skipping transfer tax, which is another 40%. All right. That also gets diminished on December 31st, 2025. So we have a great opportunity now to do some really good estate planning, to keep it private, keep it out of probate, use the high level of exemptions that we currently have, take into consideration grandchildren, children, and really build an opportunity to have a chance to move our real estate from one generation to the next. Now, there are other things that are of consideration for us as well in moving that. If the real estate is financed, is the note going to get called when we die? Other things, are there going to be documentary transfer taxes? If we live in California, is the is the property tax going to be reassessed? And we bought property 40 years ago at a very, very low tax base, and now the property is so much higher. When we die and it transfers to our children, to our grandchildren in California under the new law that exists, now that real property is going to be reassessed to the fair market value at the time of death, and the property taxes could be 5, 6, 7, 8 times of what they were, and sometimes not allow us to even hold on to the property. So and this is in states where I don't have a state death tax. In Washington, I think it's 16, 17, 18%. I'm licensed in Washington. Oregon's like 19%. In New York is 10, 11%. I mean, on top of the federal estate tax. So we have our work cut out for us. But the takeaway from here should be is that every one of us should be sitting with our advisors and looking at the game plan. What is the game plan? What is the tax? Are we subject to the tax? What happens on January 1st, 2026? How can we avoid it? How can we avoid that and still possibly maintain some income? How could we avoid in California the increase in property taxes? Oh, there is a few exceptions that we could still use with proper procedure that can move property from one generation to the next with the gift and the avoidance of the increase in property taxes. But we need time to do it. It takes 18 months at a minimum to get it done, and a special way to get things done to get that done. So we have all of that. So there is the challenges that we have. We have always the family challenges of, kids fighting, and we always have the family challenges of who's going to be in control and how the kids inherit real property. Is it they have a third if we have 3 children, or they have it in an LLC that is owned by the 3 children? Are we going to hold on to the rental property? Are we going to sell the rental property after death? There's all of these questions that come to play. I think really requires a great sit down and a great study as to what's that. And it's worth, ladies and gentlemen, millions of dollars. I'm talking, and I'm not overstating it. It's worth millions of dollars in so many different ways. Now, there's something else we need to know that is really, really important, and that is when we look at the values of properties. So I think it's important to understand what's known as discount valuations. And then we're going to talk a little bit about, or a lot about asset protection. But so this is a concept that's very important for people to understand. It's kind of voodoo math to some degree, so just bear with me. So if we have a property that's worth $10 million fair market value, and we just have it in our living revocable trust, mistake, but the $10 million. And we die. It has to be appraised, and it's to be appraised for $10 million. And then that $10 million, assuming that we're over the threshold, would be subject to 40% tax. We could pay $4 million in taxes. But if we would have taken that $10 million property and put it into an appropriately and properly designed limited liability company and or limited partnership, and not all LLCs are created equal. We're going to talk about jurisdictions, structure, number of members, management, control, liquidity, and other restrictions that can be built into the operating agreement. There is a second appraisal that's available to us if we want to gift assets to children or upon death when the estate tax is due. And those are discounts. And the discounts, we get a discount, for example, for lack of liquidity. We get a discount for lack of marketability. And we get a discount for lack of control if the LLC is structured properly. So it's not a legal Zoom, off the shelf, boilerplate operating agreement, which we want to design a operating agreement that is good for asset protection and gives us the potential for maximum discounts. So what happens is there's 2 appraisals. 1, the value of the property, and 2, the value of the LLC that holds the property. And when you apply those discounts, when they're appropriate, and we can design it so they are appropriate, we can receive 30 to 40% discount on the value of that property. So a $10 million property held inside appropriately designed LLC under current law could be valued at $7 million. That's a $3 million decrease, and that's a savings of $1.2 million worth of taxes. And for people with very large portfolios of real property, those discounts are more important than the $26 million or $27 million worth of exemptions if someone has $100 million, $200 million worth of real property. God bless them. But so we need to look at that. That is also has been over the last number of years under attack when it was intra-family. They wanted to make intra-family discounts go away, but they have not gone away. So by properly structuring LLCs and proper transfers, property taxes can be avoided. Defaults can be avoided. Millions of dollars of estate tax could be avoided. Privacy could be obtained. Probate could be avoided. There's just a lot to do. It just requires, and sometimes it's really difficult, ladies and gentlemen, to sit down and talk about incapacity and talk about death. And, we work our butts off to build everything we do. We take risks every day being landlords, and guess what? Now it all could get broken down. I would think that that planning is probably some of the most critical planning that you could possibly do, whether it's with us or some organization similar to us that's very knowledgeable in the tools and the techniques uh, for moving real property from one generation to the next dynastically with appreciation out of the estate and appropriate controls. Now, so I think we've kind of beat that up a little bit. This is not an opportunity for us to get into an exhaustive analysis. And nothing I tell you today, of course, is a legal recommendation. We always consult with an attorney. Always make sure that your specific situation is analyzed properly and carefully. But one of the things that we do need to talk about today, now remember, every time we talk about LLCs, limited partnerships, and corporations today, well, guess what? We were also talking about, like I said in the beginning, the Corporate Transparency Act. So it's going to become part of, yes, we formed the entity. Yes, we put our real property in the entity. And yes, we have filed it, with FinCEN, with the CTA Act to make sure it's just going to become normal. We might consider it intrusive at the moment, but it will ultimately become normal. But a little bit more costly to do everything. There's a cost associated with this, and that's a shame. There's no cost for filing. It's just the cost of who has to file, when they have to file, filing itself, filing agencies. It's just a lot that's going to be involved with it. But let's talk a little bit about asset protection, because if we don't protect our assets properly in today's litigious society, we won't have an estate to give, or potentially not have an estate to give to the next generation. I want to talk about something that's near and dear to my heart. I've been doing this for 40 years. I have 30 attorneys in my organization that work for me. And every day, you don't see this every day, but I see this every day. Every day is somewhere over we have 5,000 clients of our five. Something happens. Good, but the good people, something bad happens. Their dog bit somebody. The carbon monoxide detector didn't go off. There was a car wreck and people were injured. God forbid a kid drowned in a pool. The 16-year-old kid went crashing down the street with the car. It could go on and on. And old, failure to take care of the anti-discrimination laws. It goes on and on and on, and that's liability. And when we talk about asset protection, ladies and gentlemen, we're not talking about elimination of liability. The liabilities are what they are. We're talking about doubt as to collectability and to make it to level the playing field for us. Because for those of us that have wealth, the playing field is not level. So I think it's really important to understand, excuse me, there are two forms of liability. It's outside in and inside out. So let's look at the inside out liability. A piece of real estate, piece of property. We've put it into, excuse me, appropriately designed LLC. And if that property has an equity of $800,000. So when it's in an appropriately designed limited liability company, which doesn't require books, records, and minutes, and lots of other things, the liability that the landlord-tenant liability, the liability from the operations of the real estate are limited to $800. I mean, excuse me, $800,000, the equity in that particular property. So even if there's a judgment against the entity for $2 million, if there's $800,000 of equity, that's it. Now, if we don't have it in an appropriately and properly designed limited liability, look at the name, limited liability company, the liability could be end with our bankruptcy. So if you have a piece of property, it's a rental property, it's sitting inside your living revocable trust, that's the same as you. All right. Absolutely the same as you. So the liability ends with your bankruptcy. And one other one that people don't recognize, many of you use self-directed IRAs and acquire real property through your IRAs. So although it is an IRA asset, the rulings have been that you still have individual responsibility to the full extent of your net worth for something that goes wrong inside that IRA that's holding real property. So again, if we have an IRA LLC that sits inside the IRA that holds the real property, we're going to limit that liability. So, some common sense, ladies and gentlemen. So common sense looks like this. People ask me, well, can I put two, three, four properties in a LLC? And the answer is absolutely yes. Now, if they're in different states, we have to authorize it to do business in different states, but that's really ministerial, not too much to it. But if I have three properties that have $800,000 of equity in them, here's what we've done. The net worth of that landlord now, that LLC is the landlord, is $2.4 million, 800,000 times three, if I've done my math correctly. So now I have 2.4 million for a liability rather than 800,000, and it comes from any one of the three properties. So tenants, invitees, and guests on property A take down property B and property C. Yes, you have saved, two filings. All right. So we have one LLC rather than three LLCs. That's a business judgment. And one CTA versus three CTAs that are going on. But from a business perspective, I got $2.4 million worth of equity and more targets on that equity. So I think that's a business decision. It's very important, but I think it's also very important to understand that being in the real estate business as a sole proprietor, to me, I hate to be opinionated, it's a bit of insanity. Always we should be operating within a limited liability entity. Now, limited partnerships and LLCs are particularly designed well for real estate. And I saw some questions throw by about corporations. So, as corporations, C corporations are really difficult places to have real property because what happens is that not only do you have when you put the property in, it's like a roach motel, you check in, you can't check out. If you move the property back out of that entity for some reason or other, it's a taxable event. If you have an LLC that's taxed as a partnership or a disregarded entity, that is not the case. So there are some tax attributes that make no sense. But what really makes no sense is the second part that I'm going to talk to you about in the few minutes that we have left together before we do questions and answers. And that is the other form of liability. And it's the outside in liability. And I want you to understand something. More real property and businesses are lost from outside in liabilities rather than from inside out. We kind of get the idea if we're landlords, we're at risk. We kind of buy insurance. Insurance is very important. We want to make sure we have great insurance, proper umbrella coverages, but it's not the know all end all. It's really not. It's just part of the picture. We want to do all of that. But what's happened is if my wife, for example, crashes the car, God forbid, injures a bunch of people seriously, and I live in a community property stage, the same as I crashed the car, they now look at what insurance I have. Does it cover it? But if the insurance is inadequate or not enough, then they look to me and my assets. And if I have my real property just in my own name, they will place a lien on my real property, foreclose on that lien, and sell my real property. I literally had a case yesterday where someone has a home with $4 million worth of equity in it, and they have $700,000 homestead exemption in California, and they have a liability that they got hit up for $2 million, and now they're going to lose their home. And that could have helped prevent that from happening. But anyway, So now I look down inside, and if we have our real property in a corporation, ladies and gentlemen, the creditor can take the stock. So it's an S corp, C corp, corp. I take the stock. Now, if I take the stock, I can liquidate the portfolio of real property, make a distribution. We're done. In an appropriately and properly designed LLC in an appropriate jurisdiction, it's not going to happen. What's going to happen is the liability comes, and the remedy that should be available and exclusively available is something which is known as a charging order, which is a lien over the distributions that come out of the LLC. But I can't force you to make a distribution because although I have that lien as a creditor, I get no managerial control. I also cannot reach inside and liquidate your portfolio. So you can continue to operate your real estate business. You can take the rental income, keep it in a bank account that's inside the LLC. There's a possibility that the creditor will have to pay the income taxes on your dollars. So we have a lot of those types of things that can happen that gives us an opportunity if we have a liability that came because of a dog bite or a car crash, not to lose our real property. And if we don't lose our real property and we have a structured property for state tax purposes, dynastically, we can move it down the generations for our children. So I think it's really critical, again, to look at how we own what we own and the structures that we own, and how we do that to make sure that we have protection not only looking up from the operations of the real estate, but looking down. I know that if, God forbid, I have liability, I don't want to lose all my real property. If I have it structured properly, I will not lose my property. I want to drive that plaintiff towards my insurance, which should be adequate and appropriate and properly done. Three little things to just sum up the thing on the asset protection before we start to go to questions and answers. One, ladies and gentlemen, really important. It may sound stupid, but we do not and should not engage in asset protection planning after the liability has occurred. It's like calling the fire insurance agent and say, hey, my house is on fire. I don't have enough insurance. Can we increase my insurance? It's the same thing. And we get those calls each and every week. We had this problem. We had that problem. I remember that stuff you spoke to us about on Tuesday morning at the AOA. Could you do anything to help us? We may be able to help you a little bit, but we want to make sure that whatever we do is done long before any issues occur. That's critically important in asset protection planning. Two, we want to recognize, at least from this point forward, for everybody that's with me today, that your living revocable trust, that type of trust that we use for estate planning purposes, provides no asset protection for your real property, none whatsoever. And we want to also recognize that insurance is critically important, but insurance is not the know-all end-all, and a policy is not know-all end-all. I can't begin to tell you in the marketplace today how many of our clients' insurance get canceled. What if I get a judgment that's in excess of insurance? For example, we had a client up in the Bay Area, they had a mold problem. All right, there's a mold exclusion in their landlord-tenant policy that was not covered. We settled the mold problem for $100,000, but the attorney's fees were close to $300,000. So there are a lot of issues that are inherently involved. So insurance is very important. It needs to be analyzed carefully in conjunction with appropriate and proper legal procedure. And we do that to give a little bit of time, effort, and a few bucks towards looking at all the things that I just spoke to you about today: CTA, asset protection, dynastic planning. I'm telling you, worth millions of dollars to the family. Yeah, maybe a little discomfort in conversation, maybe a little time consuming at some point along the way, but extremely worth it, and you'll sleep better at night. And with that, in the time that we have left, we have a few minutes left together. I believe we have a bunch of questions. So, Paul, do you want to take over the questions in Alexandra for us, and we can do some Q&A for the next couple of minutes?
Yeah, Alexandra, I don't know if you're there. Yeah, what do you want to go ahead and read out the questions? Yeah.
Yeah, well, I'll let you also handle that, Paul. But before we get that, I did want to pull up my screen real quick so that if any of you all wanted to get a free strategy session with BarthCalderon LLP, you can text guard assets to this number here on the screen. So this is like an easy way to connect with them. If it is something that, you want a little bit more personalized, we will try to answer your questions as best as possible with the time that we have left. And if we go over the 1 hour mark, don't worry if you have to leave. We are still recording everything, and we'll be sending it to everyone automatically by email tomorrow. And I'll also send this phone number again tomorrow in the email in case you can't write it down or you're just listening in. So don't worry about that. I will leave that up for just a little while longer. Paul, do you see any good questions for us to start with?
Yeah. Let me just pull them up here. So, Harry, is there a way for heirs to get a stepped up basis in real property if you hold the property in an S corporation?
Well, the answer to that is no. The corporation itself, the stock of the corporation will get a step up in basis on death, but the real property inside the S corporation will not necessarily get a step up in basis. If it's partnership, the answer is yes. They make an election to get a step up in basis, and there may be, which we'd have to research and get back to everybody on, some election that could be made to get a step, but generally, to the best of my knowledge, the real property that's held in a corporation will not get a step up in basis on death.
Okay. If the LLC sells one property, purchases a new property, but places that property into a new LLC, well, you know what? I don't understand that question. I don't think they finished that question. All right, here's another one. What if I wanted to take all my assets, put them in a trust for the use of my relative's education, only educational use? Good idea?
It's not that it's a good idea or a bad idea. Can you create a trust for an educational trust for future generations? The answer is yes, you can. Is it a good idea? That depends if you want to help education for future generations to come. Of course you can. And we have people that do that all the time.
Okay. Ron's asking, you work with a client's accountant to help devise game plan for the client.
Of course. Although we have tax attorneys on our team and we're pretty well versed in tax law in general, your CPA is the one that's probably best versed for U.S. specific tax situation, and we would definitely work with them. However, the vast majority of the things we spoke about today, the trust, the CTA Act, the LLCs, usually are tax neutral, meaning that there's no increase or decrease in taxes as a result of doing that. The estate tax is significantly decreased, but other than that, the answer is no.
Yeah, and I want to answer Ron real quick here. You can get one-on-one with Harry directly if you text the guard assets number that Alexander put up there. Make a notation in there. I'd like to get with Harry one-on-one. Absolutely, we can make that happen. Harry, I'm just going to fire these away. After the second death in California, the parents' home and any rental property in California will get market value property tax the next year. This forces a sale because it could never support the taxes as a rental. Is that accurate?
Oh, that's as accurate as hell. And sadly, now there is a movement by the Howard Jarvis Taxpayers Association. It's called Repeal the Death Tax. That's supposed to try to help mitigate that somewhat. But the answer is true. So what typically happens, and it was the psychology behind Proposition 19 by the realtors was to force these sales. So if my property taxes go up 5 times, my rental income can't support that. It forces the heirs to sell that property, and the new buyers will have to pay the new property tax base along the way. So the answer is yes, that is true. Sadly true. However, we do have some runway, as I mentioned earlier in my talk, that there are certain exceptions that are available today beyond the scope of our talk today in California, where we can, through the use of LLCs and different transactions, if given enough time, we can move real property to the next generation without an increase in property taxes. So there is a way to do that. It's limited on time, but within the next 24 months, I believe that can be done.
Is there an advantage in having a separate S corp solely for the property management tasks while keeping real estate ownership in LLCs?
That sounds great to me. I like it. You know, it
Okay.
just sounds good. You have property management company, which is fine. Just make sure that the property management company is properly licensed if it's providing property management to anyone other than yourself. But it's a great idea to provide property management separate from the LLC because property management has its own forms of liability, associated property manager liability, and I think that's a great move. A lot of our clients are structured that way.
Okay, John's asking, does the CTA Act, Corporate Transparency Act, and that's been clarified here, somebody asked about that, compel reporting the name and address of members of a trust like it does the members of an LLC?
Interesting question and a great question. So the answer is yes and no. So let me give you the yes and no. So under the current Corporate Transparency Act, which is kind of a misnomer because it's limited partnerships, LLCs, corporations. It's not just corporations. It's the answer is yes, but a trust that is not statutorily formed, that does not have to be filed with the state, is specifically an exempt asset from the Corporate Transparency Act. It's not filed with the state. However, there is working its way through Congress, the Trust Transparency Act, which is kind of a mirror image of the Corporate Transparency Act. Whether that will have traction after the blowback that happens with the CTA, I don't know. However, if a trust, and this is important, owns the LLC, which it should because it's, you know, you got to take the LLC, you got to put it in the trust to avoid probate, you know, and all the reasons for estate planning purposes, then that trust becomes the owner of the LLC and the trust is subject to reporting. So that is the yes and no. If the trust owns the entity, then the trust becomes a reporting entity as well.
Okay, Howard's asking, when you pass property 8.5 million from one generation to the next generation, is there an trigger for an IRS audit, Harry?
Well, yeah. So let's put that in perspective as well. There's a lot of things that happen with estate administration in moving assets from one generation to the next. And just so you know, universally, whenever an estate is large enough to fall into estate tax territory, every single estate tax return is audited by the Internal Revenue Service, by an attorney that works for the IRS. Every single one. And we wait for a clearance letter for that. So that everyone is audited. There's not necessarily an audit between spouses, movement there, but when we're moving, like the question asked, from generation one to generation two, almost universally there's an audit. You bet.
Okay, and one of the last questions here is, any idea of how long it takes to run a condominium through the probate process in Miami, Florida?
Yeah, about 18 months.
18 months. Okay.
Florida's not as not very user friendly either because there's a large senior population in Florida. So the probate process there is also extensive to prevent fraud and other issues. So it's quite extensive in Florida as well. Some states are easy, some states are hard. The hardest is California, that's for sure. Florida is close behind it.
All right, Alexander, I think we've hit it.
Yeah,
The
And
Ron
we've hit the hit
asked.
and we've hit the time and
yeah.
and that's
Yeah,
great.
good job. Yeah, Ron was asking where the office is located. If you have expertise in California, you all are in California, right?
Well, we
But
have
you
expertise in
service everywhere.
California. We pretty much we're licensed in New
Yeah,
York, we're licensed in Washington, we're licensed in the District of Columbia with Colorado, other places, and we have colleagues in every state. So we are able to function in each and every state on behalf of our clients.
amazing. Janet asking, which is the best state to set up trusts?
Depends on what kind of trust you're talking about. So
Ah,
a living revocable trust is just in the generic state that you live in is fine. If we're talking about asset protection trust, which we really didn't get too much of a chance to talk about, Nevada is one of the best states to set them up to do that. If we're talking about privacy, Wyoming is good, South Dakota is good, Nevada is good, Delaware is very, very good. But traditionally, for asset protection, it's Nevada. For everything else, your home state is usually fine for trust.
Okay, well, good. I think this does wrap up the questions that I'm seeing here. So this was really helpful. I'm going to put up a quick poll question. This one is from me about whether you'd like to share your rental investing journey in AAOA's January issue of Rent Magazine. If you say yes, then I will email you and give you a couple of questions. You can either type back an answer with your story, or if you'd like to have a video interview with me, we could do that too and feature it as well. So I'm going to leave that up for just a couple of minutes. And also want to just reiterate that Harry will be back February 1st. So mark your calendars. He's going to go into full detail on the Corporate Transparency Act, which we touched on a little bit today. So if you really want to do a deep dive into that, we will be hosting that in February. We'll also be providing you with the recording, as I mentioned, tomorrow, and also that phone number if you do want to schedule a consultation with Harry or anyone on his team. So thank you all for joining us, and thank you again,
Alexandra. Thank you,
Harry.
Paul.
Thank you,
It's great to see you
Paul.
again. Thanks,
Happy
Thank
guys.
you. Yeah.
holidays.
Happy
This is
holidays
our
to
last
everybody.
webinar of the year, so we will see you next year, everyone.
Look forward
Take
to it. Thank you,
care.
everybody. Bye-bye.
Bye.